Hey everyone, so we are now on to part 5. Just to clarify as well, because Wayfarer have uploaded their unredacted Rule 56.1 statement. I'm not going to be doing that as a separate thing because I don't need to, because their statements are in this one document and they've also got livelies in this document as well. So I'm able to kind of kill both sides, the two birds with one stone. Thankfully, this is such a long document. So I'm just going to concentrate on literally the highlighted parts now, because I keep going back and reading a bit more then to give more context, but I think we all know what I'm talking about. So I am literally just going to focus on the unredacted bit as much as possible. So like this point now is moaning about Lively, what she complained about Baldoni suppressed. And basically, Wayfarer is saying, well, nearly half of the incidents she identifies merely claim that the defendants either suppressed content about Mr. Baldoni or enhanced positive content, which is how PR works, according to Leslie Sloan. Okay, so in August 9th, a statement by Baldoni to the press that every movie is a miracle, and then, of course, you're navigating complex personalities and trying to get everybody on the same page with the same vision, and mistakes are always made, and then you figure out how to move past them. Abel's efforts on August 10th to amplify an interview with Baldoni suggesting that the film could actually make a real difference in the fight to end domestic violence. Abel's reference to another cast member's interview saying that he had a positive experience working with Baldoni on the film. I think that was Brandon Sklenar, because he really, he did a People interview, which was really positive about Justin, saying how great he was. Efforts to quiet or kill stories claiming Baldoni behaved inappropriately on set. Efforts to suppress an individual's false claim that Baldoni had invited her up to his hotel room. Nathan's August 13th request to her sister, a gossip reporter, to write that when Baldoni commented that Lively was ready to direct, he still wanted to be involved in any sequel of the film. Okay, it's a nothing burger. So Lively does not dispute that Baldoni made a statement to the press that every movie is a miracle, and then of course you're navigating complex blah blah blah. That statement, she does not dispute it. Does not dispute the August 10th one either. The efforts to amplify an interview with Baldoni suggesting that the film could make a real difference in the fight to end domestic violence. It's disputed though that it's disputed that Abel's requested amplification was the only request for digital engagement, including a request to boost negative content regarding Lively in the cited source. Undisputed, that Abel referenced another cast member's interview, saying he had a positive experience with Baldoni. Undisputed that Wayfarers took efforts to quiet or kill stories claiming Baldoni behaved inappropriately on set. Undisputed defendants took efforts to track social media comments that were supportive of Baldoni's account or doubted Lively's. Undisputed defendants took efforts to suppress a false claim that Baldoni invited someone into his hotel room. Undisputed that the request that Melissa Nathan made to her sister. So again, that's nothing. Lively and her profit expert on digital media also suggest that defendants had some role in resurfacing a video in which Lively made an insensitive comment to a reporter, presuming incorrectly that the reporter was pregnant, the little bump video. So that's Shusty's video. Disputed that Professor Clutter concluded in his expert report that defendants had a role in resurfacing the video, Undisputed that he identified indicia of a campaign to manipulate online discussion of Lively, including evidence that in the hours after Tag suggested that they should send the little bump interview to Jed, the comments on the video increased rapidly. But then you look at the next point then, right? Lively has not put forward any evidence to suggest the little bump video is not genuine or that defendants had any contact with the reporter. Undisputed. Sarowitz was not involved in the marketing. Right, okay, so disputed that Sarowitz was not involved in the marketing of the film, as Sarowitz regularly received press updates from Jones Works, which provided public relations services for Wayfarer and Baldoni in connection with the film, including communications reflecting social media coverage of an early fan and influencer event at which alcoholic beverages were served and Baldoni made flower bouquets. The alcoholic beverages may have been served, but they weren't promoted. Okay. Sarowitz actively monitored Baldoni's interviews in connection with the film and provided positive feedback in relation thereto. Further, Sarowitz spoke with Greenberg on August 6, 2024 about press relating to the film and provided input on influencing the public narrative relating to Miss Lively and her family in mid-August 2024. Sarowitz was not involved in hiring any PR team for Wayfarer. Disputed. Given that by August 14, 2024, after Tag was engaged, Baldoni informed Sarowitz that he was already helping by Wayfarer paying for the PR teams. Stating on August 29, 2024, that we have our press people, our PR working. Further disputed, Sarowitz was unaware of and did not approve of hiring a PR crisis team for Wayfarer, Baldoni and its executives, given that he in fact supplied at least one idea to influence the narrative on or around August 14, 2024. Okay. Sarowitz was not asked his opinion on hiring Tag, nor did he vet them. Undisputed. Except to the extent that opinion or vetting took place in connection with Sarowitz's already helping by Wayfarer paying for the PR teams. Sarowitz did not approve the hiring of Street. He consulted before they were hired, but was not involved in that decision. That seems to be undisputed, except to the extent that opinion or vetting took place in connection with Sarowitz's already helping Wayfarer paying for the PR teams. Right. On or about August 14th, 2024, Sarowitz suggested that Wayfarer should point out that after Lively had said Ryan Reynolds rewrote a scene, that the scene was initially written by a female writer. Okay, well, I mean, that's fair, that's true. Sarowitz's statements were accurate. Lively said publicly that her husband had rewritten a scene in the film, and that the scene had initially been written by Christy Hall, a female screenwriter. Undisputed that on or about August 14, 2024, Sarowitz suggested pointing out that the scene was initially written by a female writer, that the scene had initially been written by Christy Hall, and that Lively said that Reynolds had contributed to writing a scene in the film. No, you said your husband wrote it. You didn't say he contributed, you said he wrote it. His contributed was not sanctioned, it was not needed. I don't like the reframing, mate. Lively alleged that Sarowitz divulged to a witness at the film's New York premiere on August 6, 2024, that he was prepared to spend $100 million to ruin the lives of Miss Lively and her family. No witness has confirmed that conversation took place. Greenberg, the witness in question, testified that he spoke to Sarowitz at the premiere party about publicity related to the film. Undisputed that Lively alleged that Sarowitz divulged to a witness at the film's New York premiere on August 6, 2024, that he was prepared to spend $100 million to ruin the lives of Miss Lively and her family. Undisputed that Greenberg testified that he spoke to Sarowitz at the premiere party about publicity related to the film. Disputed that no witness confirmed that the conversation took place, as Sarowitz confirmed that he may have used some or all of that exact language and did not deny the conversation took place. Steve told me off record that he doesn't remember what he said, but he very well might have used that language. That's not evidence. I believe that I could have used the figure language, but not the ruining part. That's not evidence of anything. During the conversation, Greenberg perceived that Sarowitz was seemingly a bit defensive and nervous about what could happen, but seemed okay. Greenberg assured Sarowitz that he really had nothing to worry about. Undisputed, except that Greenberg additionally found his conversation with Sarowitz to be cause for concern, as Greenberg perceived Sarowitz as really aggressive and needing to be managed. There's some messages, which I have read already. I had to dial down the billionaire at the premiere who was ready for serious battle. Greenberg confirmed that Sarowitz did not state during their conversation he was prepared to spend $100 million to ruin the lives of Miss Lively. Undisputed. Unfucking disputed. Are you serious? Okay. Greenberg and Sarowitz on August 6th, 2024, regarding spending $100 million to ruin the lives of Miss Lively and her family. Steve told me off the record that he doesn't remember what he said, but he might very well have used that. But again, that's not evidence that he said it. You said he said it. Greenberg does not recall Sarowitz stating anything specific about Miss Lively or her family. He confirmed that Sarowitz did not state during their conversation that he was prepared to ruin the lives of Miss Lively and her family in any way. Undisputed. Are you fucking kidding me? There was literally a kidnap threat over this statement specifically. Conversation between Greenberg and Sarowitz on August 6th, 2024, regarding spending $100 million to ruin the lives of Miss Lively and her family. Steve told me off record he didn't. She's just repeating herself now as usual. Greenberg has no memory of Sarowitz mentioning ruining anyone's life. Undisputed. And rinse and repeat. That's fucking terrible. Greenberg recalls that Sarowitz stated, I have lawyers, and in the event I need to, and this becomes a legal situation, I'm prepared to spare no expense. Right, and that's defensive, and that's fair. You threaten someone's business and livelihood and reputation. You know, they're allowed to say that they will fight back. Undisputed. My God. Oh my God. Again, the same. She's just copied and pasted the same thing about the $100 million that Greenberg claimed he did not say. On August 9th, 2024, Danny Greenberg sent a text message stating, I'm a little concerned about Steve S. He was really aggressive when I spoke with him. I've been texting Jamie to make sure he's managed and to make sure he speaks with me before doing anything nuclear. When Greenberg wrote in his text that Sarowitz was aggressive, he was just describing Sarowitz's personality as a businessman, feeling threatened and trying to prove himself in that moment. When Greenberg referred in his text message to going nuclear, he was referring to the possibility that Sarowitz could file a lawsuit because that is the only thing that Sarowitz mentioned to Greenberg. Undisputed. And then she just copies and pastes that thing about the $100 million, and Steve told me he doesn't remember, but he might have used that language. That's just fucking shit. On August 10th, 2024, Danny Greenberg sent a text message stating I had to dial down the billionaire at the premiere who was ready for serious battle. The billionaire referred to Sarowitz. When Greenberg referred in his text message to getting ready for a serious battle, similarly just meant potentially having to get into a legal dispute. And she's just copied and pasted the same thing. Greenberg has no memory of having a conversation with anyone about Sarowitz ruining anyone's life. It was a fucking surprise. Of course it didn't happen. How many letters has Lively pasted that quote into? And all the while, the alleged witness who Sarowitz is supposed to have said it to doesn't remember him saying anything like that. And you'd think if someone said that to you, you'd remember. Nor does Greenberg have any memory of telling anyone that Sarowitz mentioned a particular $100 million figure. And then she's just copied and pasted again the same thing. Why? Because she's got no other response. Idiot. Right. As a result of Lively's conduct, Sarowitz has lost millions of dollars. Oh, disputed. She disputes that. Sarowitz would fund the studios needed, providing approximately $30 million in affiliate transfers to Wayfarer, which Wayfarer then allocated for purposes of It Ends With Us. Sarowitz's legal costs on behalf of himself and the other defendants which he is funding are not attributable to Lively. I dispute that. Disputed that other costs associated with production are a result of Lively's conduct. They are. Because while Sarowitz estimates that Lively has cost him personally over $10 million, he attributed such costs to things like delays in production, wardrobe, having to hire an extra producer, which are ordinary expenses and costs associated with a film production and were not as a result of Lively's conduct. Well, the extra composer was, the extra intimacy coordinator was, the new AD. Just ridiculous. And actually with Todd Black, if I remember correctly, they hired him at an extortionate fee. Then he went to quit after the January 4th meeting, at which point Wayfarer had to hire him, convince him to stay on and hire him at an extortionate amount, like a lot higher figure than they were initially hiring him for. And that was because of Lively and Reynolds' conduct. Leading actress creative input on the wardrobe is normal. That's not what you say. In your PGA, you say you took over the wardrobe and you bought everything. He's stating we got shut down for COVID. Did they get shut down for COVID, though? Terminating the first assistant director was appropriate because of performance. The cost also ignores the massive record-breaking nature of the success of the film, which Sony and others attributed to Lively. Of course they did. He threatened everyone. As a result of this litigation, the Wayfarer Foundation, the charitable arm of Wayfarer Studios, received threats, prompting the need for security. Sarowitz and his family members have also personally received death threats, and arson was even carried out at Sarowitz's home, and someone threatened Sarowitz's daughter's life. These events, in part, prompted Sarowitz and the board of the Wayfarer Foundation to wind down the foundation. And that threat to Sarowitz's daughter's life was made not by Lively, and it can't be proved that it was anything connected to Lively, but someone quoted, said, I think the ransom was something like $80,000. And someone actually said, if you're prepared to spend $100 million to ruin the lives of Miss Lively, you can spare $80,000 to save the life of your daughter, or something to that effect. I can't remember the exact wording. But that statement, which we now know was not said, can't be proved was said, was attributed to the kidnapped attempt. So, yeah, that was Lively's conduct. Undisputed, as the substance of his testimony, but disputed that this litigation foreseeably caused the threats and that Sarowitz shared all reasons for shutting down the Wayfarer Foundation. In or about August 2024, Baldoni's former publicist Stephanie Jones and Lively connected through a mutual acquaintance. Now we're getting into something interesting. connected through a mutual acquaintance to share and discuss information that Jones had found on Abel's personal phone. Taylor Swift. There's a quote from Taylor Swift. Oh my God. Can you believe she just called and she was like, this PR chick wants to get info to Blake? Undisputed that in August 2024, Miss Lively was approached by Ashley Avignon, who advised Miss Lively that Jones has a phone which contains the most disturbing messages she's ever read in her 20 to 30 plus career, that Miss Lively deserved to see what had been done to her, and that Jones wanted to share these messages with her. Oh, Vanzan. Let's talk Vanzan. Lively is the president and 50% owner, with her husband, of a company called Vanzan, an entity with no external operations which she and her husband use to pay her personal employees. Vanzan has no owners or officers other than Lively and Reynolds. Undisputed. On or about September 27th, 2024, at Lively's direction, Vanzan filed a lawsuit in New York State Court alleging that in August 2024, 10 unidentified Doe defendants had breached contracts with Vanzan in a scheme to damage Vanzan's business and reputation. Undisputed that on September 27th, 2024, Vanzan filed a lawsuit in New York State. Doe defendants were used even though Lively personally knew the identity of all parties involved in the film, and presumably Vanzan knows the identity of all parties with which it has contracts. Vanzan's 30B6 witness, a lawyer with no prior relationship to the entity, implausibly claimed that any information Vanzan had concerning the identity of the contractors at issue in the complaint was privileged. What? Disputed, the cited evidence does not support defendant's assertion. It kinda does. Oh my God. The delusion is high with this one. On or about October 1st, 2024, taking advantage of New York rules that permit discovery even before the issue has been joined, and of the fact that no defendants had been named who could thereby invoke the court's process on their behalf, Vanzan served a subpoena on Jones Works seeking documents related to sexual harassment or retaliation in connection with the film, as well as information about the marketing, publicity, or public relations of, for, or related to the film. Undisputed. Oh my God, it's undisputed. On October 1st, 2024, Vanzan served a document subpoena upon Jones Works, and Lively respectfully refers the court to a cited source, blah, 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 blah. Such requests were made even though the complaint did not refer to the film or Jones Works at all, nor did it have any contract with Jones Works or any defendant. Vanzan had no communications with Jones Works whatsoever prior to the service of the subpoena. Undisputed. Oh my God. At Lively's direction, Vanzan voluntarily dismissed the case on December 19th without any defendant ever appearing in the action. Undisputed. Oh my God. Wow. Oh, here we go. It's getting interesting now. It's getting so interesting now. I'm just looking for something because I intend to actually bring it up. Oh yeah, I'm going to switch screens in a minute. I'm just going to read this though. On December 4th and 5th, 2024, Lively and Taylor Swift privately discussed the forthcoming New York Times article. So they knew about this. So my metadata was right. They've been working on this. They've been working on this for a while because December the 4th and 5th, they already knew the New York Times article was coming. That was like nearly 3 weeks before the article dropped. So they must have been working on this for a while before. Wow. Swift wrote, I think this bitch knows something is coming because he's gotten out his tiny violin. Fuck. I just want to go to this, right? I'm going to go take you to my X account. I just want to show you Ashley's post. Ashley Brianna. Lovely, lovely Ashley. She got absolutely dragged when she suggested that everything that Taylor Swift has been saying is a lie about her involvement in all of this. Right? She called Taylor Swift out, said it was a lie. And she got absolutely dragged for it. Unfairly so, because she was absolutely spot on. And she also called this, right? She said that Swift's song on her new album, Cancelled, was about Blake. Because pre-chorus, right, you've got this bit here. Did you make a joke only a man could? Were you just too smug for your own good? Or bring a tiny violin to a knife fight? Baby, that all ends tonight. And we have just read that on December 4th and 5th, 2024. Lively and Taylor Swift privately discussed the forthcoming New York Times article. Swift wrote, I think this bitch knows something is coming because he's gotten out his tiny violin. So that is my friend Ashley, vindicated. And the song Cancelled is definitely about Taylor, but definitely about Blake Lively. Disputed the evidence cited does not support defendant's assertion that on December 4th and 5th, 2024, Lively and Taylor Swift privately discussed the forthcoming New York Times article. Bullshit. I don't believe either of them anymore. I don't. They're clearly suggesting that something was coming. Okay. Through the CRD, Lively and or her agents told the New York Times and other media that Baldoni and Wayfarer had not used nudity riders or intimacy coordinators on set until her intervention. Undisputed that Lively CRD complaint alleges that Wayfarer failed to adhere to guild rules. No, that's not what you said. You said there was no intimacy coordinator. There are no guild rules. They are guidelines. It is a recommendation to have intimacy coordinators for certain scenes, but it is not mandatory. So they're not rules. But she clearly said that, and very much made the suggestion in multiple interviews as well, that there was no intimacy coordinator or use of nudity riders. Bloody liar. To the contrary, the evidence cited by defendant shows that by May 8th, 2023, nudity riders were still being drafted and not signed. No, yours was not signed. You refused to sign it. They've been chasing this nudity rider since, like, I don't know, April 2023. And here, Lively's nudity rider was not signed until on or about January 18th, 2024. What the fuck does it take nearly a year? After defendants received the protection to return to work document and an all-hands meeting was convened to address the hostile work environment that Lively and others experienced. There was nothing holding up her signing her nudity rider. That was just all about control. Through administrative complaint she provided, Lively and her agents told the New York Times and other media Baldoni had routinely degraded it's nearly 4 o'clock in the morning, so sorry, I'm getting tired now. Baldoni had routinely degraded Lively by finding back-channel ways of criticizing her body and weight, including by pretending a scene in the script required him to lift Lively so he could ask her trainer about her weight and referring Lively to a weight loss specialist. Undisputed that Lively CRD complaint alleges Mr. Baldoni also routinely degraded Lively by finding back-channel ways of criticizing her body and weight, disputed that defendant's assertion that statement is false. It is false, which the cited evidence does not support. It clearly does. To the contrary, the evidence demonstrates that during pre-production, Lively introduced Lively to his personal health coach, who Lively later learned specialized in weight loss. She may have specialized in weight loss, but that's not why he recommended you to her. Oh, Jesus Christ, this really pisses me off. The person may have been a bit of a specialist with weight loss, but there was, he clearly, in his text messages, you can see he referred to her for immune support and how to do it safely because she was breastfeeding. That's the sum total of her evidence. Lively later learned specialized in weight loss. There's no evidence actually saying that this person reached out to Lively and offered weight loss help, or that Baldoni asked for it. This was a particularly sensitive topic for Lively, given that she'd only recently given birth. Now she's just playing on that a bit. Lively was disturbed and unsettled. There we go, the buzzwords again. That Baldoni had asked about her weight behind her back, especially given that she had recently given birth and was still breastfeeding. She felt violated. Lively privately confronted Baldoni about his comment and conveyed that it was very invasive and inappropriate. Oh my God. After the New York Times article was published, Nathan and other TAG employees gathered messages showing that we never engaged because we were told not to. Undisputed. Okay, God. Right. So I'm just going to read this little bit that's unredacted. It's talking about the long arm agreement, the the offer letter, basically, the conditions precedent. Oh, sorry, I am really tired, so I'm going to get to the end of this hour. Okay. Where am I? Right. So this is about the offer letter, Exhibit 6, and there was a quote that was redacted. In the meantime, since principal photography is commenced, until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the negotiated deal memo, with the understanding that lender and artist are now unconditionally pay or play for the acting fee of $1.7 million, and that the conditions in paragraph 13 of the deal memo are now either satisfied or waived. Okay. On April 18th, 2024, Lively's counsel proposed additional edits to the loan out agreement. Undisputed. Lively's counsel circulated revisions to the agreement on April 18th, which included provisions concerning sexual harassment and confidentiality that Ms. Lively's counsel had previously circulated on February 5th, 2024, and that Lanius flatly rejected on March 7th, 2024. After additional communications on or about April 29th, 2024, Meziane asked Lively to sign the loan out agreement. Lively's representative responded, "We, Blake's reps, are all speaking this week about the open issues and we'll come back to you soon." That is undisputed. The first phase of the filming began with the ALA still unsigned and no agreement reached on its final terms. Undisputed. But she does cite daily prep schedule detailing Lily rehearsals, invoice from Blakely Inc. to It Ends With Us Movie LLC for meal allowances and assistant payments from January and February 2024. Email from It Ends With Us staff stating, please note we paid for meal/training and the assistant previously. So they talk about all of the things that Lively and her team negotiated in terms of her work. This is basically showcasing how much control she had over her contract, and it is a damn sight more than the average worker has with their employer. She disputes it, of course, disputed that Lively and her team negotiated every aspect. Lively and her representations negotiated for certain terms and conditions beyond SAG minimum protections, and such negotiations are consistent with work condition negotiations for most actors of Miss Lively's stature, a reality Wayfarer did not dispute. And you know what? When I did the video where this part was redacted, I wagered that's exactly what it would say. Like, something of Lively's caliber or stature or, pedigree. I don't know, something of that kind. But yeah, I was right. She's so predictable. At the time the parties began performance under the agreement, only 20% of the provisions were subject to negotiation. Parties negotiated for more than a year. Lively never signed any long-form agreement. Undisputed, she did not sign the agreement, but she is disputed. Further disputed as misleading because only 20% of the ALA's terms remained subject to discussion around the time the CRA was executed, and both parties had commenced performance of their obligations under the ALA. And then all the invoices and meal allowances and blah, blah, blah. And notwithstanding the parties' discussions as to 20% of the agreement's terms, continued negotiations centered principally around 4 provisions out of over 110. Lively's representative revises provisions governing execution of the agreement, publicity limitations, still approval, sexual harassment, and confidentiality in February 2024. It Ends With Us Movie rejects the same in March 2024. Lively's representative reintroduces edits to provisions governing execution of the agreement, publicity limitations, still approval, sexual harassment, and confidentiality in 2024. It Ends With Us Movie rejects provisions concerning execution of the agreement, sexual harassment, and confidentiality in April 2024. Negotiations over the terms of the ALA resumed and continued for months after the CRA was executed and filming recommenced, with numerous terms remaining subject to disagreement. So she basically says misleading, blah, blah, blah. Fails to account for the reality that continued negotiations centered principally around 4 isolated provisions out of over 110. And then she basically repeats the last paragraph. After the CRA, which negotiators referred to as a side letter, was finalized, the parties renewed their efforts to finalize the ALA, and Lively's counsel continued to edit the standard terms to be included therein. She edited the standard terms to state that such terms were to be incorporated into the underlying agreement as amended. And then she basically she's just copying and pasting her responses now. I'm not even sure I'm going to keep reading this bit because I'll read Wayfarer's because she's just copying and what she copies and pastes. I'm just not going to keep reading. Lively's attorney sought on multiple occasions to strike the provision stating that It Ends With Us Movie's obligations were conditioned on full execution of agreement and inducement, but It Ends With Us Movie rejected those edits. Undisputed that Lively's counsel sought to revise the text of the execution agreement provision to reflect that It Ends With Us Movie had waived the requirement. Okay, she's basically saying It Ends With Us Movie did not contest and therefore conceded waiver. As late in July 2024, Meziane continued to ask Lively's reps to review the draft and for Lively to sign. On July 2nd, 2024, Meziane wrote to Lively's representative, "Could we please have an expedited review and signature? We sent the latest version in April, reserving rights undisputed." The last version of the draft ALA was dated May 5th, 2023, and exchanged on July 2nd, 2024, after filming was complete. That draft agreement provided that Ainsworth Movies' obligations under the draft agreement were conditioned on Lively's signature, which never occurred. Undisputed. The assertion that the version of the agreement sent on July 2nd, 2024, provided that Ainsworth Movies' obligations thereunder were conditioned on signature, blah, 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 fails to account for Ainsworth Movies' waiver of this condition, both in writing and through its performance. Okay. Wayfarer also issued payment to Lively according to the terms of the agreement, not the offer letter, and accorded Lively credit as a producer rather than an executive producer, consistent with the terms of agreement circulated on July 2nd, 2024. The final draft of the loan out agreement the parties exchanged was sent by Meziane on July 2nd, 2024. The cover email and draft are Exhibit 264, undisputed. Lively refused to sign. April 30th, 2024, text from Ange Giannetti noting that Wayfarer had been trying to get her to sign for over a year. And then a June 1st, 2024, text from Baldoni stating she won't sign her contract. Undisputed that she did not sign. The final version of the draft ALA granted Lively's loan out entity a $1.75 million guaranteed payment with an additional weekly rate of $291,667.67 for any additional days required to render service beyond the dates agreed, and bonuses should the film achieve certain benchmarks or should Lively be nominated or receive an award for her work. Spoiler alert, she didn't. In addition, the agreement specified that Lively's contingent compensation package shall be no less than the total contingent compensation payable to the director or any other cast member on the picture. Undisputed. The final draft, blah, 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 also granted Lively control over numerous aspects of her work, provided that work days would be limited to a 12-hour period between the time she was picked up and dropped off at her home in New York, with adjustments if Lively chose to stay at other accommodations. It specified Lively would receive private first-class transportation to and from set and retained the right to approve the driver and car. I don't know why all this was redacted. We saw the actor loan out agreement. It gave Lively $1,000 weekly training and meal allowance and a $1,500 weekly allowance for her exclusive designated assistant. Why the fuck does she need $1,000 to eat a week? Should Lively be required to film in Los Angeles as the script anticipated, Lively would be flown round trip on a private jet along with her 4 children, assistant, 2 nannies, and security personnel, and would receive an additional per diem for herself and her employees. Lively also retained control over the post-production schedule. The agreement provided that Lively would make herself available for post-production and promotional services on her own schedule. Should Lively be required to travel more than 50 miles from her home for any promotional services, she would again be provided transportation and accommodations for herself, her immediate family, 2 nannies, an assistant, and security personnel. Lively also retained control over all photographic stills or non-photographic likenesses of her image used in connection with the film. Undisputed that Ainsworth's movie willingly agreed to grant Lively the following contractual rights. I mean, we've read all that. I won't read all that again. in fact, I won't read all of that because I have read all of this. I don't even understand why half of it was redacted. Okay. Lively seeks the following damages. Again, this is public, but okay. A, lost earnings between approximately 41,550,956 and 87,793,592 subject to expert testimony. Lost earnings? How that you don't even earn that much. Lost profits between approximately 39.6 million and 143.5 million subject to expert testimony. Pain and suffering, physical pain and humiliation in the range of $250,000 to $400,000. That is your amount for garden variety emotional distress. If it had been intentional emotional distress, the claims that she withdrew, that figure would have been so much more, possibly tenfold. Reputational harm attributable to defamation in an amount of approximately $24,375,267, subject to expert testimony. Other reputational harm in an amount of approximately 36.5 million to 40.5 million in subject in part to expert testimony. Okay. Her response undisputed. She disclosed these preliminary damages pursuant to her obligations under federal rules of civil procedure 26A1A3 without prejudice to adjustment and subject to proof, including but not limited to expert testimony that is presently underway. Such damages categories also include Lively's claims for punitive damages in an amount not less than 3 times the amount of Lively's damages, all attorney's fees and costs incurred by Lively, and damages to which Lively is entitled pursuant to California Civil Code 47.1. Wow. As components of her damages, Lively seeks lost wages for lost acting and or producing opportunities and lost endorsements, speaking engagements, or and personnel appearances. Undisputed. As components of her damages, Lively seeks lost profits for lost cash flows to Blake Brown Beauty and Betty B Holdings, as well as lost royalties in relation to Blake Brown Beauty. And we've already established that she does not get royalties. She is claiming lost royalties. She doesn't actually get any. The Blake Brown Beauty brand was announced on July 31st, 2024 and formally launched at Target on August 4th, 2024, just months before Lively's plaint was compiled and just days before the movie premiered. Undisputed. Lively understood that following the initial promotion of the brand through Target, that sales might decline organically. In October 2024, Lively received a sales deck noting that weekly retail sales might decline as the brand come off its national promotion at Target. Undisputed. Otherwise disputed that Lively understood that sales might decline organically, which the cited evidence does not support. Betty B Holdings was formed in 2023 as a holding company to accommodate the introduction of a new alcoholic product line, Betty Booze. Betty Buzz, which was formed as a non-alcoholic beverage company in 2021, became its subsidiary. Undisputed. The Betty Buzz mixer line consistently failed to gain market share throughout its 3-year existence. Undisputed. Oh, Oh, so she tried to market it and failed, and then it got a boost from the film. Are you fucking joking? In 2023, Betty B Holdings began selling alcoholic products under the brand Betty B Booze, undisputed. Lively wholly owns Lol Hatta, which has a 40% membership interest in Family Hive. Lol Hatta is also a member of Betty B Holdings, undisputed. Lively does not have any direct entitlement to royalties which are paid to Lol Hatta. Undisputed. As components of her damages, Lively seeks damages for reputational harm. Just to double back there, it might be then actually that it was the royalties to Lol Hatta she didn't have, as opposed to Betty Buzz. So I may have made a mistake there, or Blake Brown. I may have made a mistake there. I knew she wasn't entitled to royalties on one of them. As components of her damages, Lively seeks damages for reputational harm based on impressions of the allegedly defamatory statements and impressions of the terms bully, mean girl, and tone deaf attributable to the alleged retaliation. I called it tone deaf. Like, is she going to sue Wayfarer for my statement? Undisputed. Now we have plaintiff's additional Rule 56 1.1 statement. So these are her statements now. Baldoni has stated, I have crossed boundaries and lines in my teens and 20s, not even thinking about it simply because of the pornos consuming. We've already established that was not the case. She's already said further up. Like, she texts Taylor Swift a link to the article where that statement, it was more to do with Baldoni and his experience of not having consent. Like, someone not gaining his consent. Okay, Hoover did not know that Baldoni would direct the film when she sold Wayfarer the film rights. Hoover wanted a woman to direct the film and told Wayfarer and Baldoni that she wanted a woman to direct it. Well, Hoover doesn't get to dictate that. Hoover should have sold it to someone who was going to get a woman to direct it. But what I read was that she had seen 5 Feet Apart and she liked the way that Baldoni had directed that film. And that's why she sold him the rights. I'm sure it was based on that. I do not understand where this has suddenly come from. That, Hoover gets to say, well, I want a woman. You can express that, but you can't dictate it. And she never seemed to have a problem with the fact that Baldoni was directing the film until, halfway through 2024, when everyone suddenly had a problem with him all of us, out of nowhere. When Baldoni expressed interest in directing the film, both Hoover and members of Baldoni's team at Wayfarer raised concerns. When we say, well, we're talking about Alex Sachs here. Believing a woman should direct due to the domestic violence themes. Again, I don't agree with that. Why should a woman do that? I said this, right? And it really bothers me. Justin Baldoni has experience of like abuse. He's a man. Men can be abused too, and there was a very important message about the fact, compare and contrast, of Atlas and Ryle, who both experienced significant trauma in their childhood, and the two very different paths they took, where one went on to become an abuser and the other didn't and made a success of his life. And that message was important, I believe, to potential men, that there is a choice. You do not have to, go down the abuser route because there is an alternative path. And messages like that, and I say this as someone who's been through abuse, you need men to be making those statements and that providing that messaging to other men, because abusive men or men who have the inclination to be abusive to their partner, especially like a female or a male on female relationship, men will not listen to women saying, "Oh, you should not be abusive. You should not do this." They need that message from other men. It's important. I don't like this. I mean, to assume that a woman needs to direct this film just because the theme is domestic abuse is just absolutely ridiculous. Hoover and Baldoni and Wayfarer. Hoover told Baldoni and Wayfarer she would prefer a female director, but if it wasn't possible and they couldn't find one, that I felt like of all men, with him having the platform he did based on women, that he would be one of the few men that I would be okay with directing it. Right, so she was okay with Baldoni. I knew I'd read that somewhere. Although Hoover specifically requested that the film be directed by a woman, Wayfarer and Baldoni decided that Baldoni would direct the film himself, as is his right. If Hoover wanted that specifically, that condition, she should have kind of put that in a contract somewhere. You don't get to just say, "Oh yeah, by the way, I want this," and sell with the rights to your book to the filmmaker and then start dictating how the film should be produced. She hasn't got that experience. As the director and co-chairman, all cast and crew reported up to Baldoni, who had the power to hire, fire, remove, and discipline them as he saw fit. All cast and crew were paid by Wayfarer Studios. Were they, though? Or was it Ends With Us movie? Heath was president of It Ends With Us. All department heads reported to Heath, who was a supervisor. One of Heath's responsibilities was to ensure that the set was safe. When It Ends With Us movie hired Heath as president and producer for the film, he also had limited experience working on films. Okay, but he won a Grammy Award, which is more than Lively's won. At all times, Heath reported to both Sarowitz and Baldoni. Wayfarer and It Ends With Us movie, on the one hand, and Columbia Pictures Industries, or basically Sony, on the other hand, entered into a co-finance and distribution agreement dated as of November 7th, 2022, pursuant to which Sony agreed to co-finance, co-produce, and distribute the film. Sony spent more than $28 million to co-finance the project. I'm going to stop there and then leave the rest for the next part 6, I think it is.